Hello, good evening, everyone. I can see the attendees piling in, so it looks like we're well underway. Just to introduce myself briefly, I'm Ed Ludlow and will be running the tech side of things this evening. I think most of the names who are here are familiar, so we've done these events before. Just to let you know that we are recording the session, and all being well, it will be available on the Society's YouTube channel in a couple of days. Any technical issues, please just chat to me directly. Any questions that you have for the panel, please either pop them in the Q&A window or the chat session, and I will then field them to Sir Bob as required. And with that, I will now hand over to our chair for this evening, Sir Bob Neill.
Thank you very much, Ed, and thanks as always for your help on the technical side here. Welcome, everybody. This is the latest in our series of webinars that we started doing during the lockdown. In fact, we're continuing because it seems to be a pretty good way to get people able from right across the country to join in with us. And of course, we can record them and then make them available, as Ed was telling you. So many thanks for coming, everyone. And it's part of the Society's task, essentially, to be there to contribute to conservative thought at the sort of the interface of law and politics. So our research work, delighted to see Guy Sandhurst, our chair of research, here. And that research work is a key part of this. And the production of research papers on points of law, which often are of political interest, is a key element of that too. And the idea for tonight's webinar, employment law in a changing economy, is based upon two papers that are produced by members of the Society, Jill Andrew and Hugh Rowan, who are going to be talking to us shortly. And they take a look in particular on the decision in the Uber and Aslam case and where that leaves the gig economy, effectively. But we're also delighted to have with us Paul Scully, my friend and colleague Paul Scully MP, Minister for Employment. And so I thought we'd start by Paul giving us an overview of the government's current thinking around employment legislation, and then Jill and Hugh will introduce their papers and we can have a discussion around that. So Paul, many thanks for joining us, and over to you.
Bob, it's a pleasure to support you to join your colleagues, our colleagues in that bring their expertise to bear in this area. And it's interesting. My full title is Parliamentary Under Secretary of State for Labour Markets, Consumers and Small Business and Minister of State for London for the last 18 months. And bear in mind, I was promoted in February and then we went straight into lockdown. You can boil all of that down to Minister for Unintended Consequences. It's basically been trying to really work our way through all of this in a very quickly changing world, and none more so than the flexible working that we have in the gig economy, and what we're doing around the Good Work report and moving into the employment bill, because as we look to build back better, the Prime Minister also talks about building back fairer. What we don't want to have is an economy that recovers and grows resilience on the back of the lowest paid, the most vulnerable in our workforces, and so we want to make sure that it's a recovery that can be felt by everybody, that is for everybody, and that very much includes those people. One of the great strengths of the UK economy, why we were able to bounce back in 2008, following the 2010 when the coalition government came in, we were creating more jobs than the rest of Europe put together, was partly down to the well, it's partly down to startups, but it was and SMEs, but it's partly down to the flexibility of our economy as well. Now, in doing so, there are a number of questions that I know you will be asking. You've probably already been looking at as well, in terms of, how do we make the three groups of workers, the LIMBY workers, these employees and self-employed, fit into two tax categories. What is it that we can do to make sure that we've got the benefits and the day one rights and the accrued rights in right balance for those people as well, in accordance to pay. We want to keep the flexibility, and I want to make sure that as we move forward, that legislation that we keep seeing from the Labour Party, whether it's as a result of the Uber case, whether it's as a result of their campaigns on fire and rehire, these kind of things, that legislation remains the last resort rather than the first resort. We are Conservatives. We don't just rush to banning things or restricting things without due consideration of a number of other factors. But the Uber case was an incredibly interesting one. The Independent Workers Union of Great Britain have been getting more and more vocal, more and more active in the in their criticism of the government's lack of support in their view for independent workers. And what was interesting to see, I suppose, what the court ruled on, how Uber responded to it, and how other similar their competitors and people in similar areas have considered that. The Supreme Court, I mean, you would know better than me, but the Supreme Court really looked at the definition of workers, of limit workers, and they thought there were three elements: that effectively a contract whereby the individual undertakes to perform work or services for another party, personal service by the worker, and a requirement that the other party to the contract is not a client or customer of any profession or business carried out by the individuals. And so that's how they were defining worker, and then looked at how much control Uber had. At the time, bear in mind, this was a good few years ago. Uber have changed their contracts since then, and clearly competitors like Bolt and Free now have sprouted up around London and other cities in the country. But Uber was pretty dominant force in that area at the time, and the court looked at the 5 areas of control, the 5 aspects of control as they saw it in the Uber case. So first of all, the first priority was of the biggest importance was that Uber decides how much the drivers got paid, and that drivers didn't have any say in the contractual terms which applies to transporting passengers. The courts recognised that Uber drivers had the freedom to choose when and where to work. Once the drivers logged onto the app, the Uber controlled the driver's ability to accept or decline taking a particular passenger by controlling the information provided to the driver, etc. They also found that believe that Uber exerted a significant control over the way services are provided, on the type of car that can be used, and limiting the driver's ability to choose which route to take, and using the rating system as a performance management tool. And that Uber restricts communication between passengers and drivers, and that drivers are prohibited from exchanging contact details. Now, what has happened since then, and the ramifications since then, that Uber have taken the view that they actually will accept the Supreme Court's judgment, not just for the 25 drivers that were subject to that, but widening their status, worker status, for all 70,000 UK drivers, so including rights like the national minimum wage, pension contributions, and holiday pay. I suppose that is testament to the system that we have. We always of law in this country. It's not like other European countries where it tends to be a far less permissive set of regulations, where you tend to have to go to court, establish the precedents first before going down a choice of how you approach worker status, whereas we tend to arbitrate afterwards through the employment tribunal service, and then case law and precedent is built up in that way. So clearly Uber's reform model has come under a good amount of scrutiny because they haven't defined the time between the driver logging into the app and accepting a job as working time for minimum wage purposes. But I suppose if you look at actually a modern day thing, a modern day situation, fast forwarding to now, from the time that the court case was taken out, there are perversities that you can look at. That what would happen if a driver had the Uber app open, the Free Now app open, and Bolt open at the same time? Would they be able to look at getting national minimum wage for each of those three platforms, despite obviously only being able to take one job at a time. So there are things that that the companies need to consider themselves. And Bolt has gone down a different route to Uber. Free Now has gone down a different route as well. What you're finding is that different drivers are preferring different platforms because some like the worker status of Uber. Some actually like the fact that Bolt haven't gone down the line, but they pay them a higher commission. So it should be the level of flexibility, as long as those workers, employees, self-employed, whatever, however they define themselves, fully understand the conditions under which they are working on. And that's sometimes part of the problem, because when you have people at the lowest pay, the most vulnerable, as I say, in society, they don't always have the information to hand. And it's just important that we make sure that we remind employees of their duty of care. But we will continue to work through working with all of these gig economy businesses to make sure that we can keep flexibility within the workplace. We've got the employment law, the employment bill coming forward, which I'm really looking forward to actually introducing to the House when parliamentary time allows. That will allow us to really embed the gig economy into our legislation, which it hasn't done before. Legislation and government can't always keep up with the new economy. It's not great at pivoting, despite seeing businesses having pivoted over the last 18 months in particular. But that will allow us the time to consolidate, to make sure that we have a single enforcement body to tackle national minimum wage, to tackle holiday pay, and any other number of abuses, including modern slavery. But also, as I say, really embed the gig economy into our thinking, into our legislative patterns. But I'd love to let me leave it there, Bob, so I can listen to Jill and Hugh, and then maybe come back at the end.
Thank you very much, Paul. That's much appreciated. It's a very helpful overview of the government's thinking on this. And so we are still likely, I gather, then to see the employment bill at some point. Do you anticipate that in this session?
Not in this session, Bob. So it wasn't in the Queen's speech, but I'm really hoping it will be soon. That can be code for whatever you think it's going to be. But,
okay, yeah, fair enough. But the commitment still remains. Okay, good. Thanks, Paul. Well, let me then move over then to Jill and Hugh. You produced two papers for us. You jointly the first one, Uber and Aslam, a new direction for the gig economy, and then Hugh followed up with a second paper in June of this year, updating it. Jill is, of course, known to many of you as a member of the executive and a solicitor specialising in employment law, and Hugh is a member of the bar and currently at Gray's Inn and starting in pupillage, I think at the moment, Hugh, isn't it? So good luck with that. And you do a lot of work, I know, for the Free Representation Unit around employment cases. So you both got experience in the field. So who would like to start?
It's me, Bob.
Okay, Jill, over to you.
Thank you, Bob, and also thank you for chairing this evening. I wanted to start, and I have pre-warned him about this, by telling a story about Paul. He was elected in 2015 and was fighting Sutton and Cheam, which was regarded at the time as a challenging seat, I think it's fair to say. I was running Joe Johnson's campaign in Orpington at the time. Apart from a blip in the 1960s, which those of a certain age may remember, we usually weigh the Conservative votes in Orpington. I then had a request from Sutton for us to put together a team to handwrite envelopes for their pledges. We put together a team and from memory addressed some hundreds, if not thousands of envelopes. We got them back to Sutton and I thought that was the end of the matter. Shortly afterwards, we received a card and a handwritten note from Paul, thanking us for all we had done. That Paul had taken the time out during a busy election campaign to do that impressed me enormously. And I think that stands as a testament for what he's gone on to do since he was elected. I promised it would be kind, Paul. Now to the difficult stuff. And the issue of the gig economy is not only difficult legally, but as Paul has said, gives rise to enormous issues politically. Before I get into the legal detail, I did want to touch on the political issues. The gig economy has been one of our most vibrant economic areas in recent years. If we choose, we can enjoy the benefits of taxis on demand, endless shopping opportunities with delivery the next day, buying things, as my husband often reminds me, or indeed I remind him, we don't even know we need it. And we can have food delivered of any type at any time to our homes. And whilst the question of the tax the platform businesses should pay and where still remains unresolved, the extent to which those businesses have contributed to economic life cannot be underestimated. Against that, there are concerns, again, as Paul has touched on, about whether those working in those businesses are being improperly exploited. Those working in the gig economy tend to be what's described as entry level. It's not a coincidence that many taxi drivers are immigrants. My own local taxi rank in Tunbridge Wells is populated by predominantly Afghan nationals. And in many respects, these are the most vulnerable workers in our economy. That said, many people value the flexibility that the gig economy gives them. And whilst most Uber drivers celebrated the Aslam victory, there were certainly some who were concerned that they had enjoyed, that the flexibility they'd enjoyed and highly valued would be lost. As Hugh and I have covered in the SCL's Uber papers, there is evidence that investors have had concerns about the position of gig economy workers, and this has impacted their investment decisions. It's said that one of the reasons the Deliveroo listing recently failed to live up to expectations was because of concerns about the position of workers. And there is other evidence of this elsewhere, and I'll leave it to Hugh to develop those points when he speaks later. Even ever the opportunists, Labour announced following the Uber decision that they plan to create the single status of worker to include employees in what they described as NIMBY workers. They also said that genuinely self-employed, whatever that means, would retain their self-employed status. Labour also announced that they would remove qualifying periods for some basic employment rights and give workers day one rights. It was said that all workers would receive rights and protections, including statutory sick pay, the national minimum wage, holiday pay, paid parental leave, and most significantly, protection against unfair dismissal. Paul has mentioned the forthcoming employment bill, and I was hoping for a little bit more information than we seem to get, but at least we know it's on its way, and I think we should all look forward to hearing further news of this when possible. 2 points I would like to make. Paul's already touched on the law of unintended consequences. And one of the concerns about an overregulated employment market is that it depresses employment. At the risk of indulging in a degree of self-publicity, many years ago in the Blair era, I authored a paper for a Conservative publication in which I argued, based on data from the OECD, that the effect of extending employment rights was not to provide protections for new groups of workers, but to inculcate the rights of existing workers, predominantly white male middle class types. Second, quoting Lord Donaldson, who some may remember as Master of the Rolls during the turbulent times of the 70s and the early 80s, in the case of Mercer Island shipping in 1983, adopting the terminology of that time, he said, "It is important in the field of industrial relations that the parties know what is and what is not offside. Clarity in the law is always important, but particularly so in an employment context." Turning to the Uber decision, as Paul has mentioned, just to remind everyone, the case was brought by 25 Uber drivers. They claimed they were workers and entitled to a number of employment rights and protections. Uber argued they were self-employed and those rights did not apply to them. As set out in the first SCL Uber paper, and as Paul again has mentioned, there are three categories, namely employees, workers, and self-employed. And the paper sets out which rights attach to which category, and I won't repeat them here. Unfortunately, the tests applied to determine employment rights, equality rights, social security rights, and even tax and pension rights are not fully aligned. So someone might find themselves classified, say, as a worker for one purpose, but not for another purpose. Lord Donaldson's wise words have yet to be fully heeded in this area, and continuity in the law across the whole range of relevant areas would be helpful. Perhaps I can leave that one with Paul and his colleagues to ponder further. I have to confess, I've never used an Uber cab, but I'm sure there will be many on tonight's webinar who've done so. I will not therefore spend time going through how the platform works, save as to say, Uber quite simply makes a weekly payment to its drivers for the sums paid by its passengers, less a service fee. By the time the case reached the Supreme Court, there were two issues in play. Firstly, whether the drivers were workers, and secondly, if so, what constituted their working time. Dealing with the question of whether the Uber drivers were workers, the Supreme Court, in a truly groundbreaking decision, unashamedly adopted a purposive approach. One of the vexed questions over many years in employment law has been the question of whether the acceptance theory of contracts can be applied to employment relationships, or whether the unilateral theory is more appropriate. If my employer decides to sack me and offers me pay in lieu of 1 month's notice, even though there is no provision in my contract enabling him to do so, he is breaching my contract. On normal contractual principles, I should be able to say, I'm not prepared to accept your breach. I want to affirm the contract and I'm going to continue working for you. But that would be a nonsense. Although over many years, the courts have declined to decouple employment law from mainstream contractual law. That is until recently. Also, there's the question of the inequality of bargaining power between employer and employee. That is arguably inherent in all employment relationships. However, it seems that the Supreme Court were particularly troubled about this aspect in relation to gig workers. In the Uber case, there was no written contract between the parties, but the Supreme Court held that Uber were engaging the drivers to carry out the functions of the private hire license Uber held with Transport for London. Thus, the true relationship between them, as the court said, had to be inferred from the parties' conduct. Building on an earlier decision of the Supreme Court, which is also extremely important, in Autoclens and Belcher, in which it was said that a departure from the normal principles of contract law was justified because of the inequality of bargaining power between the parties. The Supreme Court in the Uber case said that the purpose of the employment legislation was to protect vulnerable workers and prevent exploitation, and that such rights lay in statute and not in contract. Applying the purposive approach to the facts in the Uber case, which are detailed in the first paper and which Paul very ably took everyone through earlier, the Supreme Court concluded that the well-defined and tightly controlled parameters under which Uber drivers operated made them subordinate to Uber. They could only earn more by working more, and there was no scope for them to do so through entrepreneurship. The second question of whether Uber drivers were considered to be working was something the Supreme Court declined to answer in the abstract, and they agreed with the decision of the original employment judge at the employment tribunal level that an Uber driver was working whenever they logged into the app and were available for work. And as Paul has rightly pointed out, this still leaves open the question of when a driver is logged into multiple apps and who in these circumstances is liable and how is working time allocated in those circumstances. And I think short of legislation on that point, I'm not sure I can see how that can happen. I think this is something we can expect further litigation on in due course. But what is clear from this and other cases is the court's direction of travel in recent years has been increasingly purposive. And this has meant that the judgment of the higher courts in this area have been overwhelmingly in favour of the worker. Other cases have included judgments against Pimlico Plumbers, Addison Lee and Hermes. Lord Leggett in the Uber judgment could not have stated the position more plainly when he said, the purpose of the legislation is to protect vulnerable workers from being paid too little for the work they do, required to work excessive hours, and subjected to some other forms of unfair treatment. The Uber judgment has already had a profound effect on the gig economy, but its tentacles go much further than this, and its impact has been felt more widely across the economy. Going back to Lord Donaldson's words about people knowing what is and what is not offside, there does need to be greater clarity and greater consistency in the definitions of who is an employee, who is a worker, and who is self-employed, and the rights that apply to each category. As an employment lawyer, having to grapple with these issues on a regular basis, it's difficult to advise clients with any degree of certainty, and sometimes the contortions required to achieve the desired outcome seem cumbersome and unnecessary. It is still, I think, possible to draw a line between those who are genuinely self-employed and those who are not, even though the lines here are becoming blurred. What is less easy to do is to define the difference between an employee and a worker. Some have suggested that the way to resolve that issue is to merge the two categories of employer and worker, but I think this may be a step too far. And the advantages of a flexible and vibrant economy may then be lost to all our detriments. And that said, that's an appropriate point to perhaps hand over to Hugh.
Thank you very much, Jill. And thank you very much, Sir Bob and Paul, for having me along here. I obviously, under Jill's supervision, was able to do a little bit of research into these areas. And I think, given that I'm definitely the most junior person here, my role really is to just set up a bit of the context around it, rather than necessarily coming to any firm conclusions. So with that in mind, I thought I'd just do three quick things with the time you've given me. First of all, to set up this era-defining, really, judgment in the context of the gig economy as a whole, as it's only really by understanding what we're talking about that we're able to address what needs to be done about it. Second, I was going to canter through some of the key points made in the paper and put it with a bit more colour in the context of recent events since it came out back in February this year. And finally, as Paul has said, the employment bill hopefully is coming at some point soon, with the intention, he said, of embedding the gig economy into our legislation. And so I thought I'd just outline maybe some of the key ideas as to what this judgment might mean going forward in the gig economy. So in this second paper, we attempted to explore some of the longer term ramifications of the Uber judgment for the gig economy as a whole. And really, the gig economy has come a long way since its origins in 1920s jazz bars in New York. And it's in its early days as an economy, the gig economy was really a niche realm inhabited by the most tech savvy among us. For example, in 2005, Amazon Mechanical Turk was set up with the intention of crowdsourcing tasks that AI could not achieve itself, things like transcription. Now, I don't know about everyone else here, but that was not something that I'd come across before my research. So when Uber was set up back in 2010, 2011, launched as Uber Cab, it had the intention of disrupting and upsetting the taxi and minicab market. And I think there can be little doubt that today it has succeeded. It's a household name, and in its last pre-COVID year of reporting, it had something in the region of 111 million worldwide users and 65 billion in gross bookings. I would suggest that of the factors that led to Uber's dominance, many in fact had nothing to do with the company itself. They were really things like growing smartphone usage, growing technical literacy, and increasing worldwide connectivity. In fact, many of the reasons that Uber has been successful over the last 10 years are the same factors which really allowed Western service economies to largely move to working from home models during the pandemic. This encroachment of the Uber economy into our everyday lives has some very interesting consequences. For example, those of you who read last Saturday's Guardian would have noted a very interesting article where they suggested that supervisors at Cambridge University were in fact unpaid gig economy workers. To quote directly from the article, they suggested that supervisors who spoke to The Guardian said they gained work through personal contacts and loose email agreements, with no guarantee of how many students they would receive. They said the rate of £31 per supervision, a correction from an earlier article which said £36, failed to cover the considerable time required to prepare for them, including covering entire reading lists and marking papers, with the result that some said their pay worked out at closer to £5 an hour. It's very interesting that, to my mind, Cambridge University tutors are not in the same category as Uber workers. And I think that goes a long way to what Jill was saying earlier about how, to a large extent, a lot of these workers tend to be a part of lower paid areas of the economy and to a large part are immigrant parts of the economy. With that in mind, I think it's worth looking at something that we didn't raise in either of the papers regarding the different categories of independent workers. There was a very interesting paper study done by, I think it was McKinsey, about 5 years ago, who classified, as then was, and obviously with the pandemic, a lot has changed over the last few years. But at the point that they did the study, they suggested there were 4 categories really of independent gig economy workers. On the one hand, there were the free agents, those who chose independent work and derived their primary income from it. They made up roughly 30%. And then there were casual earners who use independent work by choice for supplemental income. Now, those first 2 categories, I think, are clearly defined by the ones who choose to go in to the gig economy. The latter 2, however, are defined, as McKinsey put it, as either reluctance or the financially strapped. The former being those who make their primary living from independent work, but they would prefer to be in a traditional job, in one that enjoys all the protections of the legislation that has been passed over the last century or so. And finally, the financially strapped are those who do the supplemental independent work out of necessity to provide additional income to their household. Earlier, Jill spoke a lot about the balance between freedom and entrepreneurship, and I think that cuts right to the heart of what the problem moving forward with the gig economy is. It's the question of how to balance those independent workers and those free agents who use the gig economy for their as entrepreneurs and look to grow and benefit society, while those reluctant and financially strapped workers who are perhaps most liable to being taken advantage of. Moving to the paper, there were 3 key drivers we suggested that will affect change really in this area, and I think they're fairly uncontroversial. Generally, it's the court, it's the free market, and it's the state. As Paul said, however, legislation should be a last resort and never a first resort. The first resort, I think, quite rightly in this case, was the court, and we saw that in the Uber judgment and many of the other judgments that Jill has just referred to. And in particular, this Uber judgment has laid a clear marker for workers' rights, which in time other gig economy platforms may meet. The big issue with that is in time. The courts are not exactly a speedy process, and neither are they one for the faint of heart. So second is, of course, the free market. Now, the free market has, of course, been in the spotlight over the last week or so, in particular, when it comes to drivers' rights and benefits, albeit in the context of HGV drivers and not taxi drivers. I'm not really in a place to comment on the former, but regarding the latter, there are a couple of examples which I think might be helpful in understanding the UK's role on the global stage, really, in this area. As Jill mentioned, I think the first is the Deliveroo IPO from earlier this year, which fell from its valuation high of around 8.8 billion all the way down to 5.1 billion after just 2 days of trading. As Jill did mention, a number of firms suggested that one of the reasons, although not the only reason, was because of the investors' concerns over workers' rights. These weren't purely moral motivations, but reflected an investor's fear that Deliveroo profit margins would be at risk if they were required to change their rider benefit scheme. Now, this stands in stark contrast to the IPO of a company called DoorDash in the States last December. They control roughly half of the US's food delivery market, and they reached a valuation of 60 billion on their first day of trading, up around 86% on their initial offering. Many of the other reasons why Deliveroo's IPO failed so dramatically, things like its dual cost share structure and the fact that they'd never successfully turned an annual profit, were reflected as well in DoorDash. It would be beyond narrow-minded to put Deliveroo's comparative failure down just to this Uber and Aslam judgment. However, I think it would also be reckless not to consider a growing emphasis in the UK on workers' rights as a factor. I would suggest that the US are far behind the UK, really, in their protection of gig economy workers' rights. The exemplar case is California's Proposition 22. This has been an on-running situation really for the last 2 years, if not longer, and it was designed to exclude gig economy workers from legislation that assumed all workers were employees. Uber, alongside 4 other of the sort of gig economy heavyweights in California at the time, invested over $180 million campaigning for Proposition 22. And it passed last November to some public outcry. And there are still continuing protests from what I think is fair to describe as the reluctance and the financially strapped workers who were negatively affected by this proposition today. The contrast between the role of the free market in the US and the UK is stark, but in my opinion, not really surprising. I say not surprising because the UK really has been far ahead of the rest of the world in this area for a very long time. If we look back to Theresa May's government, they originally commissioned the report on modern working practices, which I think Paul briefly mentioned at the beginning, all the way back in, and it was published back in July 2017. And just very briefly, I wanted to wrap up by summarizing a couple of the key recommendations as relevant to gig economy workers, because I think it's an interesting platform off which we can discuss the future really, and what needs to, or what people perhaps feel as though ought to be included in this proposed gig economy bill. Obviously, the future is still uncertain, and I think Paul's absolutely right to say we need to let the dust settle from the last year and a half, really, before we can make any conclusive recommendations. But I do think that 5 recommendations from what's known as the Taylor Report should just be quickly gone over. And the first of those Jill mentioned, which is aligning the legislation for employment tests with tax law. And it's a very simple recommendation to my mind, obviously harder to enact, but it was argued, I think effectively, that enshrining a single test in primary as opposed to secondary legislation would ensure greater clarity and accessibility for all of the workers and employees affected. The second recommendation was using the phrase dependent contractor instead of the third category, which was mentioned earlier, the Lim B workers. Lim B workers being quite an obscure and legalistic term, dependent contractor perhaps being easier for the average worker to understand. Third is the notion of removing the requirement for personal service. As Paul mentioned earlier, this was key, or at least part of the Supreme Court's judgment in Uber and Aslam. The idea being that initially it was thought if you could substitute yourself, so hand over your work to someone else for another worker, you would be classified as self-employed. It was because in that case the work wasn't personal. So Taylor suggested instead that the test really should focus on those things that later ended up being enshrined in the Supreme Court judgment of Uber and Aslam, and in particular he suggested that the test ought to focus on this notion of degree of control. Of course, Uber was deemed to have exercised almost an excessive degree of control, to the extent at least that it wasn't fair to classify the drivers as self-employed. Fourth is the notion of providing written statements for all workers. All employers would be required to provide employees with a written statement setting out their terms of employment. This obviously is perhaps a little bit idealistic. In the real world, that's not how a lot of employment relationships begin, and not everyone has a legal understanding or a solicitor to draft such terms of employment. And so the fifth recommendation and the last one I wanted to address was Taylor's suggestion regarding the determination of worker status. And in particular, he suggested, or the report suggested, an online tool to determine employment status in the majority of cases, as well as reversing the burden of proof, something that Proposition 22 in California directly opposed. That was the legislation that had been originally imposed in California, reversing the burden of proof. Now, these 5 suggestions, I think it's fair to say, veer between the quixotic and the merely cosmetic. However, there is a middle ground somewhere, and this happy medium, I suggest, can be found over the coming consultation period prior to the employment bill actually finding its way through Parliament. However, I think from the research I have done, the UK is a world leader in the way it has approached the employment status of gig economy workers, and it should really do its best to stay as much. And that's all I have to say. Thank you.
Thank you very much, Hugh. Well, thank you both. Because I think those are very erudite and clear expositions of where we are opposed to. But yes, certainly quite positivist it is in its approach, isn't it? But it's interesting too that it's not a Brenda Hale judgment in that context. This is the currently constituted Supreme Court, which is generally perhaps a little more judicially conservative. Many would say in its attitudes. So the fact that they felt that there was something which required judicial intervention, court headed up by Robert Reid and others, suggest that that approach to the law isn't going to change any time soon, it would seem to me. Does that sort of fit in with your understandings of it, both? Yeah. The other point I noticed, Hugh, that you made, whilst anybody wants to put their questions, can you type them up or put your hand up? If you type them up, we can feed them into the Q&A window, and then I can sort of mediate them. Another thing that struck me, that amongst the things that clearly you think are less quixotic is the enforceability point around rights. It's something that the Justice Committee, which I chair, looked at in terms of our reports on access to justice around quality of arms in tribunals, where the fees were concerned. Is that something that essentially would require legislation, do you think? Or is it something that could be done by changes either to legal aid regulations or other matters of practice?
Well, I think you're right. The enforceability. I think one of the big issues, and from my limited experience with the Free Representation Unit, in terms of that sort of access to justice and enforceability, is a lot of people don't know about the steps that they can go through. And particularly what Jill said at the beginning, that a lot of these, particularly Uber workers, do come from immigrant communities and are low pays, and therefore may not know that they do have these rights. And therefore, I think that's why some of the other notions, like perhaps reversing the burden of proof, might help. And I put it out there as opposed to suggesting. I think that's the conclusion that should be reached.
Yeah, no, okay. So the online tool interesting me because we're seeing much more movement towards that in some other areas. But Jill, you've got your doubts about that.
Yeah, I have to say, I mean, there are a couple of points I wanted to pick up on, if I may, on Hugh's comments arising from the Taylor report. One of those was the question of an online tool. I mean, the HMRC have been using an online tool for, well, they've been doing it sort of pretty much internally for deciding whether somebody is self-employed or not. And I think it's proved to be quite dangerous in practice. And that sometimes the nuances, if I can put it that way, are missed in these circumstances. So I think an online tool is a rather blunt instrument. And again, back to the law of unintended consequences. Two other points, if I may briefly make on the Taylor report. I mean, the whole concept, and I think this is absolutely key, and again, Paul touched on it when talking about the actual outcome of the Uber decision, is the key in all these cases has and always has been the degree of control that the employer exercises over the worker. And that is the key to everything. I mean, as a young student, law student, rather more years ago than I care to think about, we were always taught that there was a difference between a contract for service and a contract for services. And, you know, always at the heart of that was the question of the degree of control that was exercised. And I think it's actually distilling out where the lines are drawn between that degree of control is where the art in this lies. And if I can just say finally on Taylor about people having written contracts, under the law as it currently stands, all employees now have to have what's called a written statement of terms of employment from day one of employment. It used to be you could be in employment for 13 weeks before you had to do that. And a statement of terms of employment, or whatever that may be, is not necessarily a formal employment contract, but it does set out the terms. And I think most employers nowadays, or employers in whatever category, can put together a one-page set of terms and conditions which would comply with the legislation. So I don't see that as a huge barrier to overcome.
That's helpful. Guy Sandhurst has just added a question to the chat, to all of the panel really, but give Paul a chance to make some observations around what he's heard. What three matters would the panel give priority to for legislation arising out of the Uber and Aslam litigation, if legislation be the route?
Yeah, well, it's interesting. I suppose to come back to the fact that it's the last resort rather than the first resort, I think the two things that come out of the decision is, first of all, that we need to remind employers that they have a duty to actually go through and make sure that they have the appropriate terms for how they're defining their employees or self-employed or LIMBY workers, and that they are treating their people fairly. But similarly, we need to also work, and we're considering at the moment what we can do to make sure that that people in the workforce can understand their rights themselves. So that's really the immediate areas that we'll be looking at. So we don't need an employment bill for either of those sort of things, but that's the way forward. There are wider issues in the gig economy that we'll look to consider in the lead up to the employment bill. There will be the kind of questions about surety of shifts and hours worked and those kind of things, because Jill's absolutely right that people in the, and Hugh was saying that the majority of people do like 0-hour contracts that work within them. They fit them around their life, they fit them around their caring responsibilities and those kind of things. However, the hard pressed, as Hugh was talking about, the financially pressed people, these are the people that actually we've got to make sure that they have the right hours, that they're not just left hanging for days on end, not sure what shifts they can and can't work. And that's the kind of consideration that we'll think about in the lead up to the employment bill.
Okay, thanks. That's helpful, Paul. Jill, Hugh, if you were advising Paul, if there was a bill, and when it is, well, we know there will be a bill, any three bits that you think that it should pick up on the back of Uber and Aslam that should be priorities?
I come back to a point I've made before. I think the most significant thing at the moment that could be done is the alignment of the tests for employment across the whole range of government, from employment through to social security, through to tax and so on and so forth. And I think that would assist greatly. And I think it would sort of take away the confusion that lies not just in the minds of lawyers, frankly, but also, I don't understand how somebody can be told 1 minute that they are a worker for this purpose, but not for that purpose. And I think, if we're trying to create a fairer world, then clarity of rights, I think, is important. Yeah. The second thing is defining clearly what is an employee, who is an employee, who is not an employee, and so on and so forth. And I mean, there are elements of that within the employment legislation already, as I'm sure Paul and those advising him will know. But as often tends to happen, by the time the courts get their hands on these things, they sort of often veer off in a different direction. And the third thing is to actually identify which rights should properly apply to which category of employees. I mentioned Labour being opportunistic. There's a surprise. But I would be hugely concerned, and I hope I've not misunderstood what they are saying, that if unfair dismissal protection were to become a day one right, across a whole range of employee, worker, and so on and so forth. Because if anything, and I can tell you this, and most of my career I've acted for employers, although not exclusively, and some very large companies amongst them, I can tell you, if anything is destined to kill employment opportunities, it's creating day one rights in unfair dismissal. So, as always, there's got to be a balance. But I think, again, taking Paul's point, we shouldn't rush to legislation and see that as the ultimate answer, because it may not be the answer.
You any thoughts?
Yeah, I think I'd very much agree with Jill in terms of the first of those, that it is pretty surprising how disparate the tests in different areas in pension law, tax law, employment law, even different areas of employment law there are between these different types of workers, confusingly called LIMBY workers in multiple different places, even though they may have different tests applying. And that has to be the first thing or at least the most important to my mind. The second, I think Jill sort of touched on, but I think more touched on earlier, and that's really, I think the test should be simplified as much as possible. And I do think there is some scope for removing, I think this notion of personal service is to some extent antiquated, particularly given the ease with which jobs and tasks can be passed off between people, thanks to the connectivity we have, thanks to the ability we have to just ping something over on Microsoft Teams or whatever platform people may use. And really, instead, I think the focus should be on this degree of control and the other aspects set out by the Supreme Court. And finally, I think sort of bringing together what Paul and Jill were saying in this notion of accessibility, and employees, workers, and the self-employed all understanding what exactly their rights are. And I think things like I perhaps was a little too quick to judge or at least dismiss the Taylor Report's suggestion of redefining LIMBY workers as dependent contractors. But actually, it's steps like that which may appear cosmetic that do eventually add up and produce something, or at least enable workers to understand a lot better what rights they have and should have going forward. And just, I think, lastly, to comment on what Jill was finishing off with, I think you're absolutely right in terms of this slightly strange proposal by the Labour government, because of course workers, as you well know from all the work you've done, do have rights from day one. If they are somehow, so long as if there's a statutory breach, something, or protected disclosure, or some sort of contravention of the Equalities Act, then workers do have rights, and those, I think, as Conservatives, we're all happy to support and accept. But beyond that, many of the other rights that you do take 2 years to accrue, or otherwise, or a year and a half for various rights, it would entirely stifle development and innovation as people refuse to take on more workers.
Can I just come back on the personal service point, because I think this is particularly important. If I'm advising a client, if I'm advising clients on either side of the divide as to whether or not somebody is or is not self-employed, the key test that I know other employment lawyers apply is that of personal service. Now, if it's a personal service contract, then it is probably straying into the worker category. Whereas if it is a contract in which you can provide a substitute, then it is more likely than not that it will be regarded as self-employed. And I arranged, what I've just done recently for, dare I say, for an editor of a national newspaper moving into a consultancy role, that we particularly provided therefore a substitute arrangement. And what I often say to clients in those circumstances is make sure you've got a substitute and use them from time to time, because that way you get through the self-employed test as it currently stands better than most. And I think there's a big difference between an Uber driver passing, I'm sorry, this sounds terribly snotty and it's not intended to be, but there are different categories of employees, workers, and so on and so forth. You know, an Uber driver passing on a fare to a colleague is somewhat different from an editor of a former editor of a national newspaper who goes on to provide consultancy services, providing a substitute to fill in a piece of work at one point in time. You know, there are different gradations here. And I think this personal service thing is quite a difficult area. I've just, if I may, I've just picked up on Mark Dunkley's comments about, I've seen in the chat line, if others have picked this up, about the problem of being able to enforce their legal rights through the employment tribunals. The subject of legal aid was mentioned, but legal aid hasn't ever been available in the employment tribunals. So that has always been a bit of a barrier to justice. All I can say on that at the moment, and assuming legal aid is not going to be extended ever to employment tribunals, and I certainly don't contemplate that ever happening. But, you know, I think there are a number of organisations who do offer very good representation in the employment tribunals. Bob spoke of the work that Hugh does for the Free Representation Unit at the bar, which does a superb amount of work on enforcing employment rights. Citizens advice bureaus, and of course most unions have legal teams that assist with access to justice.
Okay, Jill. Yeah, I'm going to suggest that's an interesting point. I mean, Mark, we're going to Ed can unmute you. Did you want to develop that point? Concerns that you had there.
Thank you. No, I just wanted to highlight, which I'm sure many people on this call are aware, how complex this area has become with workers, employees, self-employed, all the rest of it. Often there'll be tax advantages or disadvantages to one or the other. But it appears, certainly in tertiary education, that it appears to have been over the recent years an inclination by universities and others just to put people on extended zero-hours contracts, which seems to me to be on the verge of exploitation, but also it makes it very difficult, for example, for them to get mortgages and things because they don't get paid for holidays or have employment rights. And I'm not sure that can continue with maybe the vacancies we've got, but maybe it will continue. I don't know. It just seems to me that the whole world here has changed from what would logically or be acceptable to people.
It's a fair point. Certainly, I've seen in my constituency case work issues. I mean, IR35 and the things around that certainly created quite a lot of casework and after a range of sectors, from people in financial services through to, as Mark says, people on really quite low levels, like van mount. Obviously, given my wife's work as well, peripatetic music teachers in schools, and so on. And that the issue of the substitute, and the ability to send that. So if your singer's off sick, or your violinist or somebody's off sick, how do you do that naturally? Really quite confusing, even for pretty bright people and pretty well.
There's an interesting thing there, Bob. Actually,
yeah.
Here's the thing, if I may, because you talked about peripatetic music teachers. My other half is a head teacher at prep school, and that's actually one unintended consequence. So the peripatetic music teachers that have enjoyed their self-employment, the school now can't give them a free school meal.
That's right.
It's absurd, isn't it? It's just, it's just a simple little thing like that. No, you can't have a sandwich. You got to pay for it or go somewhere else. Again, unintended consequences because bureaucracy upon bureaucracy upon bureaucracy.
Yeah, absolutely right. And Louise, as you know, was head of music at one of our local prep schools. Exactly the same thing. Paul Scully couldn't go and get somebody in the canteen in their gaps between lessons, which was probably none of us thought, but was likely. So probably does suggest there's need for some rationalisation, as Jill suggests, around the test there. Any other contributors from our audience? No, have we kicked it around to a fair degree then? Okay, well, there's always thought schools be fed in by the society, of course. Any of our panelists, any sort of wind-up remarks then?
Well, Bob, I mean, for me, it's been really informative. It's been incredibly helpful, as I'd expected it to be. And Jill, by the way, thank you so much, because what you did in your colleagues in Orpington have allowed me to get to the position to be even discussing all of this sort of stuff. Otherwise, I'd have been back running my business, worrying about employment rights from the other end. of this, but as a poacher turned gamekeeper. But the gig economy, it is supposed to be disruptive. That's the entire point of it. Uber in itself has been controversial because it's just stoked up feeling with the black cab drivers, with the Mayor of London in particular, and other cities around the world, which has put a big target on its back in many ways. And I'm guessing Will Shew and the Deliveroo guys have got. I love the way that 8 odd billion quid is a comparative failure, but I'm sure he's got a few billion reasons to compensate him for that. But in looking at the gig economy, what that's given us as consumers is choice. It's given us flexibility. It's giving us lower prices. So within any of these areas, when we look at workers' rights, we've got to make sure we get the balance right, as has been said, because otherwise you get it's our convenience. We've got to pay for extras. If you're going to add layers of bureaucracy, extra layers of rights, someone's got to pay for that. It usually ends up as the consumer, frankly, anyway. So let's get the balance right with that. I think the employment bill. A lot of that is teasing out. It will be looking at things like neonatal leave, about flexible working as the right, a day one right to request, and these kind of things. But what we're looking at is allowing the dust to settle, as someone said, post-COVID. We would have got on with the employment bill a long time ago if it hadn't been for COVID. Now with that coming in, we've now got time to allow the dust to settle, start kicking around what the post-COVID landscape looks like. And really work through some of these things. But that has been incredibly helpful for me. But we must not we mustn't forget the politics of it, because the Labour Party, as you say, do tend to just go for the big brands. They think that actually legislating is going to help the workforce, the most vulnerable in the workforce. Actually, what it's going to do, as Jill said, it's going to restrain job creation, job opportunities. The fire and rehire debate is a case in point. If you remove the flexibility, actually what you do, you start to move towards redundancies rather than other flexibilities. So I think we've got the balance about right.
Yeah, that's I very much again. You've only got to look at some of our continental neighbours with much more rigid labour markets and the impact that has actually on youth unemployment and unemployment generally. So unless there's anything else from Jill and Hugh. Yeah, Jill. Yeah, surely not.
Sorry, I can mute. Can I just make one very small point that has possibly got lost? And can I say, I voted to remain, but a lot of the employment rights come from Europe. And maybe the bill is an opportunity, and I put it no higher than that, to look at things with fresh eyes.
Well, I mean, that is a thought, and there are one or two areas. I mean, we're in the same boat there. Watch for the paper that the Society is producing on public procurement law, which is another area, as Paul will know from his time in local government, where I tore our hair out about the overkill of OG procedures. But at the moment, we haven't made any significant changes. We basically sort of cut and pasted what was there. And I think a lot of people in local government would adopt a similar chart view in relation to procurement law. In fact, if there's from the point of view of us who were on that side, we've all moved on now. That could be actually an unintended area for benefit if we wanted to be imaginative on it. But Hugh, anything at your end?
Well, actually, if Paul's got time, he's mentioned how he's now really become Minister for Unintended Consequences, and looking at what's happened over the last year and a half and moving forward with this employment bill, this is perhaps the most unfair question I could ask. But what is is there something that looking at the employment bill and the gig economy, the party is particularly worried about triggering unintentionally with any legislation on the gig economy, other than the obvious aspects of sort of stifling innovation? So I know it's quite an unfair question, but it just...
No, I'm not sure I can think of anything at this moment in time. I think what it is trying to get the balance right to make sure that, like I say, embedding gig economy into our employment thinking and law, but also making sure that we're not adding undue costs to businesses at a time when they're trying to bounce back from the pandemic and trying to recover. I started off by saying we don't want to do that recovery on the back of the lowest paid workers, but it's just making sure that we really kick the tires to get that balance right between employers, flexibility, and the rights of the workers. It's a, that's why the next year will be really good conversations to have, and I look forward to continuing chatting to you and Jill and Bob and others.
Thank you very much, Paul, and that's probably a pretty good positive note upon which to end up, not least for this reason, because we are here to help. As a society, we've got a range of expertise in our members, as you've seen in just one field tonight, but a raft of other areas of business law, not to mention other elements of the jurisdictions. We're here to help. I'm sure your SPADs and officials will already be aware of the 2 papers that are up on the, if they haven't seen them yet, they're up on the Society's website, open free to all, just like British Justice and the Ritz Hotel, so do by all means plunder those, and do by all means come along, and if you ever need picking your brains, that's exactly what we're here for, to give back up to our Conservative government in helping to deliver in the most legally robust and creative way we can. So, Paul, great to see you. Many thanks for your time. Great to see Jill and Hugh and everybody else who's on the call. And have a great time. Have a great rest of the evening. I'm going to start having a look at the Judicial Review and Courts Bill. That probably counts as cruel and unusual punishment, but there you go for when we're back next week. But many thanks, everyone. It's been a really useful evening. Ed, many thanks for doing all the techniques. That's great as ever. And see you at our next webinar, which we'll be advertising ere long. Many thanks all. Good night. Cheers.
Thanks all.